This video contains excerpts from an online workshop that the USALI Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by USALI Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
This is a quotation that's commonly referred to in the United States. The cross-examination is beyond any doubt the greatest legal engine ever invented for the discovery of the truth. That may be a little bit hyperbole or exaggeration, but its cross-examination is certainly the best tool we have to try to get to the truth in a judicial process.
The principle that the accused in a criminal case has a constitutional right to confront witnesses against him is embodied in our Constitution. It's a bedrock principle of criminal defense, and it really stems from the idea that this is among the most important rights that someone accused of a crime has, to confront the witnesses against him, which means that the witnesses have to be brought into court. The accused has a right to be present, and the accused has the right to have his lawyer, or if he waives his lawyer himself, but that's a rarity, question the witness live in front of the court or in front of the jury. And that's considered it's certainly among the most sacred rights that a defendant holds under the United States Constitution.
This principle that Larry was talking about, the notion that a defendant has the right to confront the witnesses against him or her, essentially means that they have the opportunity for cross-examination. That principle was enunciated most recently and most powerfully by the Supreme Court in the case of Crawford versus Washington. It is the crux of the opportunity to confront the witnesses means the opportunity to question the witnesses and cross-examine the witnesses against you. That case involved a husband and wife, Michael and Sylvia, who had gone over to another man's house, Mr. Kenneth Lee, because they were upset and claimed that this man had attempted to rape Sylvia. A fight happened between Michael and Kenneth was stabbed. Michael was subsequently charged with assault and attempted murder, and his defense was that he had acted in self-defense, that in fact Kenneth had threatened him with a weapon in his hand, and he had only stabbed Kenneth to protect himself. Now, at the trial, Sylvia, his wife, could not be compelled to testify against him, because under Washington state law, no spouse, no husband or wife can be forced to testify against the other unless the spouse consents. So the prosecution used instead her recorded statement. She had been interviewed shortly after the incident by the police, and used that tape recorded statement against Michael at his trial. And they did so because in the statement, Sylvia said that she did not see a weapon in the hand of Mr. Kenneth Lee before her husband stabbed him. That statement was at odds and in contradiction with the statements by Michael, her husband, and so the prosecution claimed it defeated the self-defense claim that Michael was making, and was a basis for his conviction. Ultimately, the Supreme Court held that the use of that recorded statement was impermissible. It was an out-of-court statement. and Michael and his lawyer did not have the opportunity to cross-examine her at the time the statement was made, and therefore could not be used to convict him at a subsequent trial. And I think it's important to note that both Sylvia and Michael had given statements just following the incident to the police. So these statements were made to police officers. They were recorded with tape recording machines, and they were done shortly after the incident in question.
As you can see from the facts of the Crawford case that Justine just laid out, it clearly implicated the rule against hearsay testimony. And this is another bedrock principle of evidence in the US courts, is that hearsay is generally speaking not admissible, although there are many exceptions to that rule. But basically, hearsay is an out-of-court statement that a declarant has made, and any statement made out of court would be considered hearsay. And the problem with hearsay is you have someone on the witness stand who is not the declarant. In other words, the witness says, yes, I heard somebody else make this statement outside of this courtroom. And therefore, the attorney for the defendant has no ability to examine and cross-examine the actual declarant of the statement. Instead, you can only cross-examine the person who heard the statement. And that's a very different thing. So the basic rule against hearsay is that that's not admissible. Someone can, generally speaking, not take the witness stand and say, I heard someone else make an important statement, assuming that you're trying to bring that statement in to prove the truth of what that outside the courtroom declarant said. That is, generally speaking, not permissible.
The fundamental principle of having an opportunity to cross-examine the witness is not exclusively an American idea. It's also the principle as part of the Chinese criminal procedure law. And our trial systems are different, but I think the notion that there should be an opportunity to challenge the testimony of witnesses is common to both systems.
The opportunity for cross-examination, for example, in a hearsay statement, is to test the reliability of the information being imparted. If someone is on the witness stand and says, someone else told me X, Y, Z, and assuming that the truth of that is of relevance to the trial, it is critical to be able to test the reliability of the declarant's statement, not the statement of the witness that it was said, but to test the actual person who made the statement to understand if it's reliable or not. Perhaps the out-of-court declarant was just repeating a rumor to the person on the witness stand. Now the person on the witness stand testifies to this, and it comes in as if it's true, but perhaps it was just a rumor. It had no factual basis. So the key is to allow the lawyer an opportunity to develop and challenge the accuracy of what the declarant of the statement said, rather than only cross-examine the person who heard the declarant make the statement.
I just want to emphasize the word reliability, which could include credibility as the person telling the truth. Were they mistaken? Or as you said, are they just repeating a rumor? And if you don't have the person who made the statement in the courtroom, there's really no opportunity to find out.
Exactly. It's an opportunity to test all of those things. It's to test whether the declarant is being truthful. Does the declarant have a motive to perhaps testify falsely? It's to be able to test, did the declarant have an opportunity to observe what he or she said he had observed? And so it's basically, as it says in the slide, it's to afford greater confidence that the testimony that's coming in at trial is in fact reliable, and it's all about the reliability. So we came at this in the direction of through the hearsay rule, but I did want to point out that, of course, the concept of cross-examination is far broader than the hearsay rule. Cross-examination is critical even when the testimony being cross-examined has nothing to do with hearsay, even when an eyewitness is testifying in the courtroom to something he or she claims to have observed. The same issues of reliability, bias, accuracy, mistake, all those issues apply, even more so when it's an eyewitness who's giving testimony. So I just wanted to clarify that the cross-examination rule is far broader than just the hearsay context.
So let's think about the facts of that case again. Remember, the wife had given a tape recorded statement to the police. And at the time that she gave the statement, she was not a victim and she was not adverse to her husband. And so some of the lower courts accepted her statement because they thought that it was neutral and reliable. And so she would have no reason to hurt her husband or make up bad facts for him. And so they could take the statement because even though it was hearsay and there was no opportunity for cross-examination, it was still sufficiently reliable to be used in court. But here are some ideas of what a lawyer for her husband might do or might question her about if they did have the opportunity for cross-examination. For example, we don't know, unless she's present in court, whether or not what the police questioned her about that day and what they recorded her saying was the complete record of her statement. What if following the recorded statement, she said, oh, now that I've calmed down, I actually remember more about this incident, and said additional facts which actually supported her husband's defense. What if a lawyer could ask her about where she was during this entire fight that was taking place in the house? Was she cowering in the doorway and peeking from around the side of a wall? Did she really see, as things happened so quickly, did she really have a good opportunity to observe what was in his hands when she claimed they were above him? This was obviously a very stressful and difficult event, a fight. Did she have her eyes closed? Was she so stressed and upset that she didn't really have a full opportunity to observe what was happening? Perhaps she doesn't have good vision and she wasn't wearing her glasses that night. Maybe she's actually really in love with Mr. Kenneth Lee and she was trying to protect him, and so she didn't tell the police the truth that night. And maybe she is actually trying to hurt her husband because he's an abusive husband and she wants to get a divorce. Who knows? Maybe the relevance of this is minimal because even though she didn't see a knife, maybe the relevant question is that Michael believed that he saw a knife, and that belief was in good faith. And if he told her at the time that he saw that, maybe a lawyer on cross-examination could draw that out of her, thereby supporting his defense, even if she didn't independently see a knife. So there's many things that a lawyer acting on behalf of Michael could question her about if she was present in court, to put the statements that she made, the recorded statement, in context and make it perhaps not as powerful as it might at first seem. While cross-examination is a very important right and fundamental to our system and perceived, and in the Constitution, a right that's given to the accused, to the defendant, ultimately its benefits are not unique to the defendant. It's not just something that helps the accused. It's something that gives confidence to the outcome of any court proceeding, even if at the end of the day, all the attempts to discredit or impeach or put in context a statement are unsuccessful. At the end of the day, then the trier of fact, the jury, the judge, will know that they can rely on that statement because it's been tested. So it's a way of vetting and testing the reliability of a witness's statement. Sometimes the test comes out and the witness has failed the test because they are not deemed credible enough in order to convict the defendant. Or sometimes they pass the test, and despite robust questioning from the defense lawyer, they remain credible and consistent, and the trier of fact, whether it's the jury or the judge, believes the witness and finds them sufficiently credible so that they can rely on that witness's statement to reach a judgment in the case. So really, it's not just about giving the defendant a right, which is obviously, it is very much about that. But beyond that, it's also about making sure that the fact-finding process yields an outcome that is reliable and one that everyone who participates in the system can have confidence in.